give to. Let me know if you're seeing any signal.
I got notice that it was being recorded.
Okay.
I have as well.
All right, now I'm going to go back to YouTube. All right, let me begin. Hi, neighbor. Welcome to Can We Talk, a discussion program by neighbors about neighborhood issues. And the program tonight is about the DC bike plans and ADA compliance. This program is brought to you by Hear Us Now, the listserv for the neighborhood discussion, and by DuPont East Civic Action Association, dedicated to community engagement and civic action, and by the citywide coalition on DDOT bike plans, which now boasts more than a dozen partners around the city. Let me introduce our principal speaker tonight is Ed Hanlon. Ed is an attorney with the board of DECA, and we're very proud to have him speak tonight on this issue, which is still breaking. It's really a new event, and I'm going to turn it over to you, Ed. And then when he is through, we will have question and answer, but don't hesitate to ask questions. In the meantime, choose the raise hand and I will know that you want to ask a question. Go ahead, Ed, please take it over. You're muted. You're muted.
Get over. Yeah, can I take it over now?
Yes, please.
As many of you know, an ADA lawsuit was filed in November challenging DDOT's policy citywide concerning both the design of these, they're called protected bike lanes or cycle tracks. In fact, DDOT uses both terms interchangeably. And it also addresses the appalling lack of handicapped accessible parking throughout the city. As you may know, the city's official position on handicapped accessible parking is that it's not required to provide any handicapped parking outside the central business district anywhere in the city of Washington, D.C. And that position has been stated in writing. It was also stated at the February town hall meeting, which Director Lott attended. Not only did he state it, he repeated it, then he repeated it a third time to make sure everyone heard that they're not required to provide any handicapped accessible parking. That is one reason in the construction of the 17th Street cycle track, there's not a single handicapped parking space anywhere north of Massachusetts Avenue. In fact, there are new proposed bike lanes, about 10 miles of them are going to go, many of them are going to go into Northeast. And again, I was looking at the DDOT presentation for those new bike lanes, and they go block after block after block with not a single handicapped accessible parking space, even when you have small neighborhood business districts and stores and churches, there's no handicapped parking. So this lawsuit seeks to address two things: the design of the present cycle tracks or bike lanes, and the lack of handicapped accessible parking. And 17th Street is the example used in the complaint. The complaint's almost 50 pages long, but it goes into great detail about 17th Street because 17th Street is a very good example of what the city is doing wrong. If you think about it for a moment, suppose that you are in a wheelchair or you use a walker. Picture 17th Street, which is a one-way street. if you are the driver of that vehicle, you want to be independent, you want to drive around the city, as one of the individual plaintiffs in this case does, Dana Bowles. She has her own vehicle, she has a handicapped accessible ramp, and she drives all over the city, even though she's a quadriplegic. But on 17th Street, where could she park and set up her wheelchair and get out? If she parks on the west side next to the Safeway, she's setting up her wheelchair in the middle of oncoming traffic. There's only one lane there. There's no Safeway for that lady to be able to set up her wheelchair and visit 17th Street. If she try to set up her wheelchair on the east side, next in front of the hardware store, well, she can't do it, right? Because you have the plastic vertical pylon, you have the horizontal cement blocks, and even if she could set up the wheelchair, where does she go? She could set up, if she could set up the wheelchair, then she would immediately move into the bike lane. And she cannot get out of that bike lane because there is a 4-inch curb there. And that 4-inch curb might as well be a 10-foot wall for somebody in a wheelchair or walker. And so she's forced to go down that bike lane to the nearest intersection or curb cut. Similarly, someone in a walker has to make that long journey. And anyone who may have ever used a walker or had knee surgery and used crutches, you know how difficult it is just to go a block in a walker or with crutches. And that is a phenomenal burden that's being placed on disabled individuals, where before the bike lane, they could simply open their door and set up the wheelchair directly on the sidewalk and access the sidewalk directly. And so 17th Street is a very good example of what's wrong with DDOT and what's wrong with these bike lanes, because those who have mobility disabilities have the same rights as the rest of us to participate equally in the life of the city and in the life of their neighborhood, and to be able to go to the church they want to be able to go to the food store they want to be able to go to the restaurant they want to. And these designs totally ignore those legal obligations that DDOT has. In fact, when I was looking at the most recent presentation for the new bike lanes in Northeast, they not only do they not have any handicapped accessible parking, in the major presentation, which goes on for I think 40 pages, it has it's videotaped, it has, as they're speaking, there are screenshots, diagrams, graphics. And you know, they considered everything about except one thing. In that 40, 50 pages of DDOT's presentation from this summer, there's not a single mention of the ADA. There's not a single mention of how we make these sidewalks accessible for people who are mobility impaired. And that's the passion about what this lawsuit is about. This lawsuit has the ability to fundamentally change DDOT policy on how it designs bike lanes. This lawsuit, there have only been a few lawsuits in the country about bike lanes and the ADA. And there's a famous one from the summer of 2020, Safari in Los Angeles. But that was about a man in a wheelchair who wanted to use a particular block or a couple of blocks. And that's what that case centered on. But this is fundamentally different in that this is about an entire city and how we make an entire city accessible, not just the 1 or 2 blocks that this one individual wants to be able to access a sidewalk. And we have we have 2 individual plaintiffs and 2 organizational plaintiffs. We have the DC Center for Independent Living. You're welcome to Google them and go to their website. It's a beautiful website. And they do tremendous work helping the disabled. And they have a passenger bus, like a Metro Access van type vehicle. And they are reporting problems in being able to pick up and drop off the mobility impaired using their own access van because they can't get close to the sidewalk. And this is a fundamental problem for them because that's what their mission is. To be able to help the disabled be able to equally participate. And then we have two individual plaintiffs. As I said, Ms. Bowles is a wonderful person, quadriplegic, more independent maybe than any of us, who expresses her profound frustration about the limitations that are put on her by the design of these bike lanes and to where she can go, and the lack of handicapped accessible parking. And then we have Theodora Robinson, who lives over in 7th Street, uses a walker, has a bike lane in front of her building. And again, Theodora has expressed the real problem she's having accessing the sidewalk. So she can't get close to the sidewalk because there's a bike lane in between her, a protected bike lane in between her and the sidewalk in the places she wants to visit. So these are the issues that this lawsuit addresses. This case will go on for some time. Now, DECA, along with the DC Center for Independent Living, Ms. Bowles and Ms. Robinson are the plaintiffs, 2 organizational plaintiffs and 2 individual plaintiffs. And it could take several years to litigate. But I'm confident that we're going to make fundamental changes, and this lawsuit's going to be cited around the country in the end. I've not met a single person who, when they've heard that DDOT's official policy is no handicapped accessible parking outside the central business district, thinks that's right in the 21st century. And even many avid bikers find a real problem when they sit and think, because many of these bikers are in the 25 to 35 year age bracket, healthy, majority male, and they haven't really thought about how does someone in a wheelchair get across that bike lane to the sidewalk. And many of them express the opinion that it is not their intent to try to deprive access to the sidewalks for those in wheelchairs and walkers or who use canes, or may even have visual issues. And so it's a lawsuit with a lot of, I think, a lot of underlying empathy and sympathy among the citizens here in the District of Columbia. Are there questions?
That was a wonderful presentation. Are there questions? Raise your hand, use the tool. And I'm using gallery view so that the speaker can be seen. Let me start off by saying that it appears to be a determined policy to put the bike lanes on the curb. We need a good explanation for that. They seem to think that the bikes are safer on the curb, but it interrupts all the other people who need the curb. And that would be the handicapped people, a lot of deliveries. Who wants to raise a question? We have our attorney ready and, oh, here we go. David Krukoff is known in the community. He ran for office. Tell us a little bit about that and ask your question. Thank you, David.
Hi. First off, I came in late. I apologize. So I might have missed some of the things I might want to ask about. Could you talk about timeline and which part of the court system you're petitioning?
Yeah, the lawsuit is filed in U.S. District Court here in Washington because it's filed under the Americans with Disabilities Act, a federal statute, and the Rehabilitation Act, which is the federal statute. The complaint was filed in November. I spoke with Maya Goodell, one of the disability attorneys. I should have mentioned we're being represented by 2 sets of attorneys. We're being represented by 2 different law firms. We're being represented by a major law firm out of New York City, Maya Goodell, well-known disability rights attorney. And we're also being represented by another disability rights attorney in the city of from the city of New Orleans, and Garrett DeRouse. And so we're blessed with two experienced attorneys, major attorneys, who have taken this case on, and they only get paid if they win or they substantially prevail. You know, or they settle and they get it substantially the relief requested. And so they have made a great commitment in terms of time. We could be talking about hundreds of thousands of dollars worth of attorney time. Michael might have a better idea of this than me. Probably could be easily talking over $1 million of attorney time.
I'm sure it's going to be over $1 million.
And they think, at least their operating assumption at the moment is, they may end up putting out at least $50,000 in out-of-pocket costs doing this litigation. Not only for depositions, but they're going to need several different kinds of expert witnesses in street design and safety to go forward with the litigation. Maya told me today the city's contact. Don't laugh, Iris and Michael, you know this. The city has contacted them and their answer is due. And they've asked to extend the time they can answer to the first week of February.
That's
And
ridiculous.
yeah, but there's not going to be any opposition to it because in a sense, what's the point? By the time you do the opposition and they do the opposition, they file a motion, you do the opposition, the court decides the issue, it's almost February anyway. And
Let me say for the record that today is December 12th in
Yeah.
2022.
yeah, but I mean, as a lawyer, I generally always gave my opponent an extension of time if they requested it, unless it caused prejudice. So maybe I'm overly liberal in that.
So, and who's the judge that's been assigned? Do you know?
Oh, good question. I did not look that up today. I apologize, Mike. I don't know. That's a very good question. Maybe as you're giving your presentation, Michael, maybe I'll log in on PACER, U.S. District Court website, and try to find the judge.
Okay, Lee Meyer. Did that answer your question, David? Are you, was it? Okay, Lee?
Yeah, I was wondering, how much is the lawsuit over and above the legal fees? Is there going to be damages for, is there a total amount they're suing for in addition to the right of handicapped people to park at the curb?
No, there's no request for individual damages. Individual damages would be tough to get in this type of ADA lawsuit, I'm told. So no, they're not being requested. The relief that's wanted is a fundamental change in DDOT policy, access to the sidewalks for those people who are mobility impaired, a major increase in handicapped accessible parking throughout the city, so everyone can enjoy going to every part of the city. And because of the civil rights type statute, the prevailing party normally gets their attorney fees.
Mhm.
Thank you. Jerry? Go ahead,
Well,
Lee. Go
I
ahead,
just
Lee.
want to touch on one other thing. I
Yes.
believe you were aware of this, Ed. I reached out to DDOT regarding the K Street, and I just wanted to see what metrics they were using to gauge success or failure. And just so everybody on this call knows, DDOT declined to respond because of the lawsuit. And my question had nothing to do with the lawsuit with handicap access.
Well, it's a DDOT has been sued. I mean, the city's been sued, but over DDOT. And so DDOT is in essence a litigant to this issue now. And it would not be surprising, I suppose. It's convenient, but also, I suppose, not surprising that they take that position. I mean, similarly, Decker, and I would think the DC Center for Independent Living and the individual plaintiffs also would not be contacting DDOT directly about the plaintiffs shouldn't be contacting DDOT directly about the bike lanes because DDOT is represented by counsel and vice versa.
Well, of course, but I'm not plaintiff.
I know. I mean, they threw the net pretty wide. I agree.
Yeah, they're very wide, very
Yeah,
wide.
very convenient, very wide net.
Yeah.
Well, they have they may have a problem because they're continuing, or at the moment, they plan to do more like town halls. They have to do citizen engagement for all these new 10 miles of proposed bike lanes they want to build this year. And it's going to be an issue for them, isn't it? About how they engage citizens, but not answer the questions. It's really interesting.
Jerry, do you have a question?
Yes, good evening to everyone. Ed, I do have a question. Excuse my ignorance to the law or this type of issue, but I know this is ADA, but like I'm on Kenyon Street in Northwest, and they've already put the bike lanes on Kenyon Street. We do have a transportation engineer that lives on our block, and he said, well, they erred on our street because the street is a major thoroughfare and they weren't supposed to even put that type of bike lane on that type of street, first of all. But my question is there any way that this could turn into like a class action lawsuit where, because we don't, on our particular block of Kenyon, I'm going to just say 70% of the residents don't have backyard parking. So they have basically just wiped our parking out. And we have a stroke victim and a older woman who does oxygen, and Metro Access can no longer pick her up on our block. So is there a possibility that this could turn into a class action?
The attorneys don't want to do it as a class action and don't believe it's necessary to do as a class action, I'm told. Because not only do they have the two individual plaintiffs, but they have the DC Center for Independent Living, whose very essence is about providing access throughout the city to those who are mobility impaired, and that the same relief citywide can be obtained this way rather than the more cumbersome, I guess, complicated, expensive class action. But what I would say to you is, if I can put my email address in the chat, or just give it to you now, if you can contact me about these individuals, because what the attorneys want is they want to be able to talk to other individuals all around the city who have mobility issues, so that they can gather stories, because all these people, the stories of the people on your street can also be part of the lawsuit. Their stories, because the more stories in the more neighborhoods, the stronger the case and the stronger the relief that can be eventually granted. So it's important that people speak up, stand up, speak up, so that, and I'll be happy to do that. I'll tell you my email address, and then I'll try to put it in chat.
Okay.
It's my name. It's ed.hanlon, HANLON .3@gmail.com.
You
If I
say
went
dot
fast,
3?
yeah, ed.hanlon, HAN like Nancy, LON .3@gmail.com. If you can contact me, Mr. Burnett, and we can talk, arrange to talk, or you can give me just a snippet of information about the individuals, and maybe I can, if they're willing to let me contact them, I can contact them, we can contact them together.
Okay.
And talk to them about their issues, because anyone here who knows someone who has such a story, it's very important that these stories be told as part of the lawsuit. They don't have to be a plaintiff to have their story told.
So Ed, one other question, preliminary injunctive relief. Does a complaint ask for that? I mean, you're probably not at liberty to say whether that's intended, but if this is going to take, I mean, I don't know what the average length of these lawsuits is. It's probably a couple of years. I mean, preliminary injunctive relief, assuming the case can be made, which it sounds like, just from listening to what Jerry was saying, sounds like there are a lot of people that, are being impacted on a daily basis on this stupid rule they have.
Mhm.
So, I mean, any response to that?
I don't have a good response at the moment. Thinking it through, the injunctive relief may in fact be helpful and useful in this setting, because we're not talking about a static situation here. We're talking about the building 10 more miles of bike lanes this year. And they're building those bike lanes without any handicap accessible parking, when the obligation to do so is clear. And they're spending millions of dollars doing something that's wrong and partially will have to be undone. And so I will address that issue, Michael. Maybe I can report back in January.
Yeah, I was thinking, you know, in DC, they have the sliding scale. I believe DC has adopted sort of the sliding scale. So if you could show either a strong likelihood or a strong irreparable harm, then the other things become less important. But it does seem to me that these people with disabilities are suffering on a daily basis from this. And so it seems like you could probably make a pretty good case for irreparable harm. And the stupidity of the idea that this ADA, even though the statute doesn't say it, is somehow limited to the central business district, where there's nothing in the statute that even remotely suggests that. And it's completely illogical to begin with. It seems to me a likelihood of success on the merits. You've made that case. So anyway, I would urge the law firm. I know it can be expensive and it's a little distracting, but if you prevail on that, then the city may cave, and they may cave very early on, particularly if you get a sympathetic judge. And it seems to me it may be a chance worth taking. So,
Well, that's very thoughtful.
let
We
me
have a
say-
couple of people who want to raise a question. Who's talking?
I want to say one other thing. Michael
Go ahead.
made a good point
Go
about
ahead. Yes.
there
go
are
ahead.
all sorts of people you don't know about. I won't tell you his name because he told it to me in confidence, but he's actually a major businessman of the city who does a lot of work for city government as a contractor. And Iris would know him, I think. And he contacted me because he read about this lawsuit and wanted to talk to me about his mother-in-law, because his mother-in-law is in a wheelchair. And it's just a terrible time he's having with his mother-in-law and getting that wheelchair set up on the sidewalk because of the protected bike lane. There are these stories all over the place. We just have to gather them.
you present 20 affidavits in connection with a motion for a preliminary injunction. And I don't know, I would find it very difficult to believe that a judge is going to deny it, but I don't know the law in this area, but it seems to me like it's a pretty clear-cut case. So anyway, I certainly would raise that with the lawyers and see if you can get them to do it, because I mean, another waste, not only wasting the taxpayers' dollars, but subjecting all these people with disabilities to 2 years of, horrible inconvenience. It seems like preliminary injunctive relief, this is sort of tailor-made for it.
Okay, let me call on iPad number 2. Can you introduce yourself? Who is iPad number 2?
Oh, it's Alex Kelly. I'm sorry, I didn't realize.
Oh, wow, it's all right, Alex.
Hi. Ed, thank you for the presentation. That was really helpful. And I don't know if I got your email right, but I did send you an email about someone who wanted to be participating in the lawsuit. And actually, a couple of other neighbors have said the same. I have a number of elderly relatives in my neighborhood in Capitol Hill, Lincoln Park area. So
let me put my email address in the chat now, as after you finish, to make sure that I get it.
Yeah, absolutely. Because a couple of long-term residents, older people with severe mobility issues, I think they'd love to tell their stories.
Hi, can anybody hear me? This is Lester Cuffey from the Friends of the Frank Reeves Center.
Yes, we can hear you. Lester, go ahead.
Oh, no, I just came in and just wanted to introduce myself. That's all.
Lester, we're streaming live on YouTube, and right now we're talking about the disabilities lawsuit. Thank you for being here.
Mm-hmm.
Okay, thank you for a full discussion. We still have a meeting to go. We'll pull this to who has more questions for Ed. We'll end the YouTube broadcast. All right, let me go get started. Thank you, Ed Hanlon, for your efforts on behalf of the community. Thank you to our sponsors, Hear Us Now, DuPont East Civic Action Association, and the citywide coalition on DDOT bike plans. And thank you, our neighbor. There is strength in community engagement and civic action. A video of this program is available on YouTube on the channel DuPont East Civic Action Association. Hit subscribe and you will not miss any of our episodes. We hope you enjoyed the program tonight and that you will listen again for